Okay, Naima, let's just wait for the other students as well. And I would just like to, start the video.
Okay, we will wait.
Okay. One, two, three, four. Then there are two more. Okay. I will just start the video. One minute. We'll watch it again for those who came late. So you have seen the Donahu versus Stevenson case in an animated form. So we'll go back to our slides now. Ooh, 1 minute. What's happening? Oh my God. 1 minute.
This case may well be the most.
Okay, so we were on this slide. Um, Elements to be proved in the case of negligence. Now, after having seen what is Donahu's facts and how the case proceeded, now we will see what are the elements to be proved in the case of negligence. Now, of course, one factor that needs to be proved, you already know, is the duty of care. And this duty of care came about in 1931 case of Donahu versus Stevenson, and it was a duty of care which was actually put forth by Lord Atkin. So therefore, one of the most important element to be proved in the case of negligence in the law of tort is the duty of care. The defendant owed the plaintiff a duty of care. Yet another factor is that the defendant now, who had the duty of care, has breached the duty, has failed to perform that duty of care. And as a result, the plaintiff suffers loss or damage as a direct consequence of that breach. Now here in brackets, causation must be proved. Causation simply means the relationship between cause and effect. What is the cause of the damage? What is the effect of the damage? So cause effect is causation. Now let's go in detail to the duty of care. What is a case law for you here is Donahu versus Stevenson. Mind you, you'll have to give me case laws since it is a law subject. And you'll have to give me with the citation, especially your marks will be cut if you do not give me the citation and you do not give me a proper case law, especially if it is, a landmark case law. For example, on the question of negligence, Donahu versus Stevenson has to be there. Without that, a major chunk of your marks would be cut. Are you understanding me? So, duty of care. So the plaintiff first must establish that the defendant owed him or her a duty of care. And the duty of care can be established by applying the neighbor test set out in Donahu versus Stevenson. Once it is evidenced, that is, it is proved that the defendant owed the plaintiff a duty of care, then the plaintiff must prove that the defendant was negligent and breached that duty of care by being forgetful, by being oblivious. That means by being forgetful, of following that principle of who is my neighbor, or of forgetful of being careful, or has displayed a careless attitude. So therefore it says that by being oblivious or forgetful to exercise a relevant standard of care. Now again, this is a very important term that has to be in your answer. Relevant standard of care. You need to highlight this point. Duty of care and relevant standard of care. What is relevant standard of care, or what is standard of care? It implies a care that can be exhibited by a normal, prudent person. They're not saying expertise. They're just telling, just like a normal person would be, that kind of care, if it is exhibited, is more than enough. Next is there is breach. The next element is breach of that duty of care. Now, to establish that there has been a breach of that duty of care, it is necessary to examine whether, one, there was some risk involved. The question here is whether there was a risk, whether there was some kind of risk involved, and was that risk foreseeable? Was the problem foreseeable? And was the defendant's response to that risk reasonable, or was it exercised as a man or a woman of normal prudence? First thing is, he has breached the duty of care. Now, having breached the duty of care, whether he could foresee, as a person of normal prudence, as a normal human being, whether he could foresee the risk. And having foreseen the risk, whether he did something or did not do something, whether he exercised caution or did not exercise caution. So the problem comes when you are a person of normal prudence, or rather you're just a normal human being. That means if something that comes before your eyes, you should be able to foresee. Are you understanding? And after having foreseen, you should be able to exercise the duty of care and stop that damage from happening. Stop the damage from happening. And if after foreseeing it, if you have not done anything on your part and you have just been careless and caused damage to people and property around you, that means you are liable under the law of tort, because there are two elements that are already proved against you. One is there has been duty of care to the neighbor, and two, or the person who is aggrieved, who is harmed, and two, there has been breach of that duty of care, and three, now damage has been caused, injury has been inflicted, damage has been caused to the person or property, or injury has been inflicted to the person. Now here, the plaintiff must prove that there is a harm that is caused as a result of the act or omission. Act is to do something, omission is not to do something. Suppose the house is on fire, the person doesn't do anything, just, clasps his hand, clasp it, hold it together and do nothing about it. Why did you do anything about it? I felt it is not my duty to do it. Is it right? It's wrong. A person of normal prudence would go and alert the fire extinguisher system, would go and help the neighbors to extinguish the fire themselves, but by staying away from reasonable harm, not jump into the fire, but do something to, avoid further damage to someone. So not doing something also can be a wrong. Not avoiding a short circuit when you know there is a possibility of it, it's a wrong. Let me give you an example here. For example, this normally happens in companies. Say, for example, let us take industry example, or say a manufacturing unit example. Say now there are many people or workers. I'm not talking about offices, but I'm just talking about industry workers or a manufacturing unit workers. Say there are many technicians, or there are many shop floor workers. We call them shop floor workers, floor workers. Why we call them shop floor? Because they are there working on the machines, and that area is called as a shop floor. Now these shop floor workers and technicians, they are actually having expertise in handling those machines. They are trained technicians. Are you understanding? Suppose there is a kind of a risk or a danger that is lurking in the area in terms of, say, some electrical wires that are not insulated. Are you understanding me? Some uninsulated wires, some wires that are just hanging there, or bare wires, which are electrical wires, which are not insulated. And the employer, or rather the HSE, that is, you call them as the HSE team, safety officers or a safety manager who is there, or hygiene and safety manager who is there. Now he observes it and he says, well, I'll get it repaired tomorrow. And he doesn't do anything about it, and say he forgets about it, and he takes it very light, and he just issues instruction, well, don't go there, there's live wires there. And suppose there is, God forbid, an accident and a technician, inadvertently or by mistake just goes to that area, and then he gets electrocuted and he dies. So who is held responsible for this? So here there is an omission here. The employer has not done anything to insulate the wires, or at least, confine that area and say that it is hazard prone. Don't go in that area and put a board there. Do something about it. But if they don't do, and as a result, there is an injury caused to someone or death is caused, so who is held responsible? Of course, the person who has not done anything about it. So this is omission. This is an act of omission. Now here in the example I gave you, just to acknowledge that, I want you to understand here. Now the employee who has lost his life, or say just even hospitalized, or is, lost some faculties, a normal faculty in his body, say probably thinking capacity or whatever harm has been caused to him, the family members or he himself is entitled to sue the company or to sue the employer for carelessness and for, this omission, for omitting to insulate the wires and take safety precautions, or do anything for that matter that would avoid this accident, because the person who knows there is live wires has reasonably, as a person of normal prudence or as an employer of normal prudence, through the particular manager, could foresee. Any person can foresee it. They can imagine, yes, if somebody goes and touches the live wire, the person will be electrocuted. This does not require a lot of education or training to understand that if you touch a live wire, that the person, there'll be injury caused to the person, probably even death. So when a person of normal prudence, ordinary understanding is more than enough, and you have not done anything, that means the person is entitled to pay damages for the damage that is caused to the employee. Now, just to remind you a little bit here, when it comes to an employer and employee relationship, it is called as vicarious liability or vicarious liability. V-I-C-A-R-I-O-U-S-L-Y, vicarious liability, or you can say that the employer is vicariously liable for the damages that is caused to the employee because of the employer's negligence of not getting the live wires or bare wires insulated. Are you understanding me? So this is an example that I've given you. Next is causation needs to be proved. Causation means relationship between cause and effect, which means that the plaintiff must prove that harm would not have occurred but for. I want you to pay attention a little bit. We will wind up and do it during the next class, but this is something very important. But for test. Now remember, already you have learned now the neighbor test, which came about in Donahoe versus Stevenson. Now we are learning the but for test. What is the but for test? Causation has to be proved. Cause and effect theory has to be proved. Plaintiff must prove that harm would not have occurred, or the aggrieved party, the injured party must prove that there would not have been any harm caused to me but for the defendant's act or omission. If not for this person's failure, act or omission to take care, failure to take care, or an act or an omission, I would not have been harmed. So this is the but for test. So now the test that comes to the fore is the but for test. And the test implies that if not for the negligent act or omission of the defendant, the plaintiff would not have suffered the loss and damage. And if the plaintiff would anyway suffer a damage, whether or not the defendant was or was not negligent, would not entitle the plaintiff to claim damages. Are you understanding? Now say, for example, if not for the negligence of the person, I would not have suffered an injury. But suppose there is a situation that even if the defendant exercised caution or did not exercise caution, but still I'd fall into trouble. So when it is this kind of a situation, it is not necessary that compensation will be awarded to me. Possibly that if the person was not negligent, for example, I would not get any damages at all. Are you understanding? Like, for example, if the construction of a building is weak and the person has purchased a new example, say flat system. You call it a flat, or what do you call it? Okay, a flat system. You have flats. So a person has purchased a new flat. Now, say he or she is standing near the balcony, and the balcony is having glass, and the glass is not fit in properly, and the person just slips and falls from whatever floor, and the person is injured or dies. Who's held responsible for this? The person who has constructed the building is responsible for that. Now, if the person who has purchased the flat on her own or on his own goes and starts shaking the glass and tries to, do all kind of, gymnastics there, where you're not supposed to do, and experiment n number of things there, and as a result falls, and then the glass breaks. So who's held responsible for this? The building, the one who has constructed is not held responsible because he has to prove it, of course. But because of the equal carelessness displayed by the injured person, damages will not be awarded to the injured person's family or the injured person. And in case the person dies, the person's family, the aggrieved person's family. Are you understanding me? So cause and effect should be proved. And it has to be proved that if not for this person, I would not have been harmed. That is a but-for test. And also see whether the plaintiff also has contributed towards the injury or to the loss due to his or her own carelessness. Let's only finish the elements and I will stop it. Please bear with me. Now, the plaintiff, why I'm doing this is because you will lose the link otherwise. Now, the plaintiff must prove the fact of damage, injury, or loss. And this damage, as contended by the plaintiff, should be a damage that is caused as a result of direct negligent act omission by the defendant. That means there should be direct relationship between the act and the damage that is caused. Now, let us explain this with the help of a case. This is also a very important case, but it is a very recent case in the sense, of course, it is not a 20th century case, but it is the recent case, 2012, that is just recently, Strong versus Woolsworth Limited. And now in this case, there was a girl called Miss Strong. This girl was an amputee. That means she had no proper limbs. One of the limb was cut. So she was an amputee and she walked with the aid of crutches, that which helps you to walk, which helps a person who is amputated to walk. So one day she was walking on a sidewalk that is kind of a pavement, which was controlled by Woolsworth, which is a company, and they use that area as a sales area. Now, as she was walking on the pavement where this company, Woolsworth, was carrying on some kind of activities and using the area as a sales area pavement, and as this girl was walking, she slipped. The crutches actually slipped through the greasy potato chip that was on the path. There was a potato chip. You call it chip or you call it fries, whatever. So greasy potato chip that was on the path. And as a result, she suffered serious spinal injury. Now, she sued or filed a case against Woolsworth for her injuries. Why? She said that you are using it. You are using the pavement. You are supposed to keep the pavement clean. Why is that there was this greasy potato chip? And because you are in control of the area, you have not cleaned the area. So the court held that Woolsworth owed a duty of care to persons using the sidewalk that was used as their sales area, and that Woolsworth was expected to exercise a reasonable standard of care to the extent of regular inspection and removing any hazards from the area. So the court found that Woolsworth breached the duty of care by failing to clean the area, and that Miss Strong would not have slipped. Now, but for Miss Strong would not have slipped and suffered a spinal injury, but for the test was applied here, but for Woolsworth's negligence. Thereby, the court concluded that Woolsworth's failure to implement a reasonable cleaning program or program of tidying the place was the effective cause of injury suffered by Miss Strong. So you'll have to know this case as well. Next is remoteness of damages, that is how close or how far is the damage related to the extent that damages should be awarded. So I guess it's 10 minutes past 9 as per, Somalia time, and for me it's 10:10 or 10:09 rather. So I think I stop here. If you want me to continue, I would, but if you want me to stop, I will stop it here. What do you want me to do? I think I stop it here and confine myself to 1 hour. Okay, let me take your attendance. 1, 2, 3, 4. Abdul Kader, Abdul Rahman, Abdullahi, Aisha, Ise, Naima. 6. 1, 2, 3. 1, 2, 3, 4, 5, 6. Okay, so attendance will be granted, and I will post this PowerPoint in the Google Classroom as well, and also give you the notes, but we can discuss this, the remaining slides during the next class. You can just go through it and also go through some of the case laws which I mentioned. And I believe you've already gone through Rylance versus Fletcher, which we'll do in some other classes when it comes under strict liability. Okay, that's all. Good night.
Okay, very nice, Professor. Yeah, very great.
Okay, you're welcome, Luis. Bye-bye.
Bye-bye, Professor. Thank you.
You're welcome. Bye-bye.
Bye-bye.